I think, has been very mature and very interesting, and I can only say that I've been very impressed by the judges of both of those judges, both of those sets of judges. But I still think that that leaves a quite important underlying problem that is potentially a very real problem. And I approach this as a political scientist, but also with some of my personal background. And I would like, therefore, just to say a few things in very general terms, if I may. Angela talked about the situation from 1945, and I think we are dealing with concepts that came up just after the war and the terrible things that happened in the war. We had the United Nations being created to do a better job than the failure of the League of Nations. We then had the Universal Declaration of Human Rights, the Council of Europe, the European Convention on Human Rights, and then shortly afterwards the Treaty of Rome, so that there was a look at having documents that gave some international guarantees that some of the terrible things that had happened over the previous years wouldn't happen again. And I think that is the background to all of this. Now, this is something that means a great deal to me personally, because I have been born in the war in Budapest as a Jewish child. I am a Holocaust survivor of 4 ghettos and camps, and therefore the whole human rights project is something that has always meant a great deal to me, and that's why I became very active in anti-discrimination, anti-racial discrimination things as a student and later on. But there are, I think, 3 underlying problems with the hopes that have come in. The first is a historical one, but something that I am still personally battling with now. That when these declarations came, like the Universal Declaration of Human Rights and the European Convention, they were accompanied at almost exactly the same time as the end of major war crimes trials against Nazi war criminals. And the historical fact is that at the same time as these general conventions were coming in, there was an underlying decision, because of the Cold War, to let most of the Nazi murderers off, and in the words of Tom Bauer's book, A Blind Eye to Murder, that it is very striking. And it's very striking that people like Hersch Lauterpacht, one of the primary lawyers, and Rabbi Lemkin, who is a Jewish international lawyers, after the Nuremberg trials, really did very little to try and bring war criminals to trial. Their minds were elsewhere. And then in 1952, you had the London Debt Settlement, which actually meant that Nazi slave labor you couldn't hold as being illegal until the final settlement of the war in a peace treaty. And in 1990, and I was working for Foreign Office at that time, and was in Bonn when an advisor to Helmut Kohl told me, oh yes, we've arranged it, that there isn't a final settlement of the Second World War in a peace treaty. So we'll never get to that stage. Officially, the Second World War has never ended. The view of the major German foundations is that there was nothing illegal in slave labor at Auschwitz, and that is still their view now. And it seems to me that the Cold War led some very, very curious things. And in fact, one of the final things that I would like to do in my life is at least to get German authorities to agree that slave labour in Auschwitz was illegal, which they won't do at the moment. And this is very much an ongoing thing. So there is a paradox in this. And an additional paradox is that the Israeli government itself didn't follow through the war crimes. It was more anxious in the very real battles it had against Arab nations. And the interesting thing was that both the CIA and the Mossad actually didn't follow up the chasing of Nazis. The case of Adolf Eichmann was very exceptional, actually, and came up through a German Jewish lawyer. The Israelis weren't really going to chase. The CIA, and a deputy director told me last years of his life before he was dying of cancer, that they allied with Nazis because the Nazis would be anti-communist. And they would rather like that, especially in the Middle East. And so those are the agents that they tried to recruit. So that I don't think you should have, and then the Israeli government also really didn't want to prosecute many of the war criminals. And indeed, that was the reason why the head of Mossad, the famous Issachar, resigned. In the end, was dismissed by Ben-Gurion, and Ben-Gurion in '63 also left office. And so the historical background, I think, is very, very different from saying, well, genocide would be a crime, crimes against humanity would be a crime. Yes, but let all of the real criminals go off. And so I think the historical record is actually quite disappointing and disgraceful. The second, and I do think that there is a case still, I'm still hopeful of being able to bring cases so that the illegality of slave labor from the Second World War is recognized even at this late stage.
You asked me in the last of the discussion to keep you around time. You have 5 minutes, so if you can...
I'll do it in 5 minutes, yes. As you can see, well, the second question is very much a question about internationalism versus democracy. Now, I do agree that the court, especially the court in Strasbourg, has in general acted, I think, in a very responsible way. I mean, I think that its decision on the prisoner voting case and decisions on a lot of the other cases that I would tend to take very much the line, though far less background than Lord Phillips, that it may have gone beyond in certain limited cases, but that in general we're not facing some scandal in that at all. And indeed, the second opinion of having said European judges may be a very useful way of bringing an extra set of voices to bear on vitally important issues of human rights. And so I think that there is a great deal to be said for a lot of the work of the judges in Strasbourg. I think there may be more doubts later about the European Court of Justice, and certainly the work that Derek Wyatt, Professor Wyatt at Oxford, has done, that does give rise to some worry about the future of that court, which will be far more powerful than Strasbourg if we remain a member of the European Union. However, I think that we do have an issue of where the last word lies in a political structure. And this may not come up very often. It may come up once every 40 or 50 years, where there is a real important division between a court and a legislature. But in that case, and especially between an international court and the legislature, namely, who is the court accountable to democratically? Who appoints the court? What are they just there? Do they appear, these judges? And given such important decisions, how does an international system work? And second, how does that international system relate to national legislatures? And if we look back, for example, at the US Supreme Court, the case of Dred Scott versus Sandford, the slave labor, the runaway slave case that really caused the Civil War. In that case, the US Supreme Court said that Congress couldn't restrict slavery in any state. And there was really no way around it, short of changing the Constitution of the US, which was impractical. So they had a civil war. So you can imagine those occasional cases where there is a real clash between the democratically elected branch and the judicial branch. Now, it isn't something that I accuse anybody of now, but I think if we're setting up a wholly new architecture, an international architecture, it is a question that we have to ask, and that wasn't asked before, because the court in Strasbourg has only really become active in full time fairly recently. And so this was a situation that wasn't really thought through after the war about the power of the last word. And I think we do need to think it through. The third and the last point that I will make here is that human rights bring up questions of principle and of practicality sometimes. You can have a right that becomes very difficult actually to implement. And this comes often with, say, social rights, say the right to housing, right to health, right to employment. You can have some of these rights that are very difficult actually to implement. And there was a case before the South African court that came up with, I think, was it kidney dialysis, that there was a right to health, but there just weren't enough machines to go around. So can you have a right with the impossibility of fulfilling the right? I would see that as coming up with the right to asylum, which is actually a very deeply troubling one, because the question is whether the rights to asylum are in a way, whether one can bring them into being. If we have millions of asylum seekers, does there come a point that the principle and the practice are just very difficult to reconcile? This is something that incidentally was something that happened in the Second World War, and something we must stop. And so that I can stop right away. Thank you very much. Get out of that we follow their jurisdiction, but with a let-out, a trumping by legislatures, but controlled so that it comes only in a very exceptional set of circumstances. I don't know if it would be by historically, by some other way, so that you have a democratic override, but you reserve that democratic override for the most extreme cases. Now, whether that's practical or not, I've not worked out, because actually the government has been going down a slightly different line that we can discuss in questions.
Okay, thank you very much. Our fourth and last speaker is Professor Aileen, who is a practicing barrister from Matravers Chambers, as well as Professor in Human Rights Law at King's College London. Moreover, she is a legal expert on the European Commission on Gender Equality. She is also the Vice President of the Institute of Employment Rights and an executive of the Human Rights Lawyers Association. In 2007, she served as a legal advisor to the Forum on the Bill of Rights in Northern Ireland. Professor McColgan, thank you very much for agreeing to speak to us tonight. Can you share with us your opinion on the debate?
Thank you, and I'll try and be as quick as possible to allow time for discussion. I start with an apology because broadly there's been a reasonable level of support for the current situation. I think it's fair to say from the bench. And I'd like to be controversial. I began, early in my academic career, I wrote a book called The False Promise of Human Rights, just before the Human Rights Act came into force. And I think I've lived to learn the error of my ways on the analysis I then adopted, which was in about 2000. And I've just been in the Supreme Court for 3 days, where the seven justices were considering the implications of Article 14 of the Convention for the bedroom tax. Now, I don't know what way that decision is going to go, but it certainly wasn't an exercise in slavish adherence by British Supreme Court justices to what their colleagues in European Court of Human Rights had said. I just want to make a few very brief points about the debate, and I think it's important, and you haven't heard that from this bench, but it is important to contextualise the proposed British Bill of Rights in its proper context, and that to me seems to be a largely Daily Mail driven context. There is a great deal of hostility towards the Human Rights Act by people who regard it as unacceptable because Johnny Foreigner is telling us what to do, because it gives rights to terrorists, because it trumps our parliamentary and judicial system. Now, the first two of those propositions I disagree with, and the third is simply wrong. The Human Rights Act does not result in the undoing of parliamentary sovereignty. It does not give European Court of Human Rights carte blanche to tell what the UK to do. The UK has been in breach of the prisoner of return cases for a number of years now, and I don't see the tanks of any of our European colleagues parked on our lawn. So in as much as the European Court is supreme, it is supreme as the arbiter of what the Convention requires and not what the UK must do, because it's highly unlikely we're going to be invaded by anyone because of breaches of the Convention. But I'll come back to that in a moment. Of course, the predecessor to a British Bill of Rights would be the repeal of the Human Rights Act. And it's interesting to note that David Cameron in April 2015 said this would be done within 100 days of, well, either a Tory government or a defeat speech, but either way, time ran out sometime in September. And I think the reason why nothing as much has happened in 100 days is undoing the Human Rights Act will be extraordinarily difficult constitutionally. It will be difficult for a number of reasons, one of which with Scotland. It would tear up the Sewell Convention because and a memorandum of understanding between Westminster and the devolved governments, because it would happen without the agreement of Scotland in particular. Northern Ireland, the Human Rights Act is a feature of the Northern Irish settlement. So it features in the Northern Ireland Act 1998, which would require amendment, and that's not a trivial fact. That because the Northern Ireland Act 1998 was a significant plank in the settlement which has been reached in Northern Ireland, and the same is true even more so of the Good Friday Agreement. And the Good Friday Agreement and the international treaty between the UK and Ireland, which forms part of that structure, is premised on the incorporation of the convention, and it's tied up with the current model. Now, if one was to go back and start undoing that, there are real dangers associated with it. Most of you are too young to really have a sense of what preceded the settlement in Northern Ireland. But older people remember that even in the UK, even in Britain, Birmingham pub bombings, Guildford bombings, Warrington bombings, Bishopgate, Hyde Park, and in Northern Ireland where I grew up, a catalogue of murder and mayhem. And a lot of that happened because there wasn't sufficient support within, possibly particularly the nationalist community, but also the loyalist community. There wasn't enough support and trust in the state. And a significant element of creating that trust in the state was embracing human rights. Now, of course, it's not the embrace of Human Rights Act per se, but it was a proper embrace of human rights, an understanding that democracy goes hand in hand with respect for rights. And if you start dismantling that, and you start sniping that, those people don't deserve rights, these people don't deserve rights, gypsies don't deserve rights, because that's what is underlying. You only deserve rights if you comply with the planning commission. That is targeted to gypsies. And a lot of hostility towards rights is targeted at perceived terrorists, real or perceived terrorists. I mean, as I say, Northern Ireland is an example of why a human rights compliant approach to problems of terrorism is the way to sort them out. The way to sort them out is not to lock them up and throw away the key, or to put them in places where they'll be tortured. The way to sort out terrorism is to embrace human rights and bring people along. So that, I think, is a real concern, it seems to me, that underlies this notion of get away from the Human Rights Act, embrace the Bill of Rights. It's really about hostility towards rights and hostility towards people who are unpopular. And that, I think, we shouldn't, I can say we as lawyers, I'm sure we're not all lawyers, but we as lawyers shouldn't have any trouble with. Scrapping the Human Rights Act will also be largely ineffective to produce anything that a government might want to produce, unless we were also to withdraw from the convention. Because the scheme of the Human Rights Act is precisely to preserve parliamentary sovereignty. And I know we can complain about underuse of declarations of incompatibility, but as Lord Phillips pointed out, that's because of the way that barristers instructed by government have pushed towards interpretation rather than declarations. All that government has to, or all that the legislator has to do if it doesn't want to have its will interpreted out of existence, is to make it very clear on the face of primary legislation that it intends to breach whatever convention provision is. It can do that. It can still be appealed, of course, to the European Court of Human Rights. As I said before, the European Court of Human Rights can issue its judgment when the UK in breach. And then it's really a matter for the UK politically what's going to do about that. None of this takes away parliamentary sovereignty. None of this puts other people's tax on carry on. And I think much of the reasoning, or much of the argument here, in the argument against the Human Rights Act and the Bill of Rights, none of what you've heard here tonight, but a lot of what you hear, the Daily Mail kind of argument, is basically incoherent. So I think I could go on for some time, but I think I'll stop there, which will give some time for people to engage in the program.
Before we go into the Q&A session, I would like to take the opportunity to ask Professor McColgan a follow-up question, if I may. You mentioned the Good Friday Agreement, and you also mentioned the agreement in Scotland. In fact, the Prime Minister of Scotland, Phillips, recently said that it's unthinkable for a British Bill of Rights to repeal the Human Rights Act without the consent of Scotland. So do you think that there is a real risk of Britain's splitting up as a result of Britain's withdrawal from the Convention?
Britain's withdrawal from the Convention, or Britain's, the UK government's repeal of the Human Rights Act?
A repeal of the Human Rights Act which entails withdrawal from the
I
Convention.
mean, I think we are in difficulty, because despite the fact that Scotland voted to stay on board very recently, we now are facing a EU referendum, and we're facing, I think, a potential complete crisis if there is a move to the Human Rights Act. And I think people should think about whether they really want to be part of the UK, which doesn't include Scotland. I'm in the process of buying a house in France, and I think I may renew my Irish passport. But I think that is something that is a real possibility. Scotland, gazing at the retreat of possibly the EU, and the retreat of the Convention, and dismantling of the Human Rights Act, may well say, look, it was close last time, and they did different next time.
Thank you very much. We now have a little bit more than 15 minutes for questions from the audience. I'll ask everyone asking questions to briefly introduce themselves. And also the speakers, if you could please be brief in your answers so that we can have as many questions from the audience as possible. Anyone would like to go first? Please.
Hi, my name is Alex Shellham. I'm a LLM candidate in human rights law at the LSE, and my question is for Lord Phillips. Your Lordship has expressed discontent with the Alskini ruling, whilst at the same time voicing support for the living instrument doctrine. Therefore, my question for your Lordship is as follows. Given that there is no textual basis for the living instrument doctrine at all written in the Convention, is there an inconsistency here applying the living instrument doctrine to Articles 2, 3, 8, 10, etc., but not supporting its de facto application with regards to Article 1 on securing rights within a member state's jurisdiction? And if there is no inconsistency, then why not?
I think there is. I think there's a difference in principle between applying the living instrument doctrine to the interpretation of human rights and purporting to apply that doctrine to the fundamental question of in what circumstances did the member states agree that they would observe and protect these particular human rights. And the Grand Chamber of the Strasbourg Court faced this fair and square in Bankovich and said in terms, it's a quite different question. You can't apply the living instrument doctrine to jurisdiction. Jurisdiction is basically the foundation upon which the member states agreed that they would build the human rights obligations. And my own view is that it was completely illegitimate to do what the Strasbourg Court did in Alskini. They weren't honest about it. They didn't say, well, Bankovich was all wrong because of the test. They paid lip service to Bankovich and to territoriality. But once you say the Human Rights Convention applies wherever you have an individual under your control, you can forget about test for territoriality, because all you need is that control test. It will normally, of course, be a situation where you have control because the individual is in your territory. in-house gaming. You simply have control if you're in a position to shoot somebody. Because if you shoot them, you're taking away their right to life. You beat them up, you're taking away their Article 3 rights. Earlier, they're under your control. Earlier, the convention applies. It may be a very good idea that people shouldn't be allowed to play like that. But it's not what the member states agreed to. And it's those kind of findings by the Strasbourg Court that have quite largely resulted in the hostility to the Human Rights Convention. With, I think, a certain amount of justification. In this country, we have a very, very sophisticated bunch of lawyers, so far as the Human Rights Act is concerned, who are looking for trade. And there are hundreds of cases, apparently, of Iraqis and Afghanistan citizens who are now being claims that they've been unlawfully detained. For a British truth, what do? You're in Iraq or Afghanistan, invited in there to help the regime. You capture somebody, and under the local law or the arrangements under which you're there, you can hold them for 96,000. You have to hand him over to the local troops. If you hand him over to the local troops, he's getting tortured. So you can't. They're not allowed to keep him either. So what you do is catch them to do.
Thank you, Lord Phillips. Miss Patrick, do you have a response?
I was just going to say, these are really difficult questions. Nobody's saying they aren't. And actually, there have been really tricky questions that have arisen as a result of the interpretation of the Convention and asking. We can agree to disagree. It's an argument for another day. I think there's a lot of really interesting exploration there. But I think what we can all agree on is the British Bill of Rights introducing a limit on the Human Rights Act or whatever mechanism is put in place, which prevents the extraterritorial finding and redress in this country, doesn't remedy it. Because actually, that just means that those people who are seeking redress don't come to our courts, don't come to our judges, they go to Strasbourg. This is an issue about the convention. And we can agree to disagree, we could argue all day about whether Afghani is right or wrong, but the remedy isn't in depriving people of a remedy in our courts, and that wouldn't just be Iraqis and Afghanis and all the rest, it would be our troops who might seek redress for when they are treated in an ill manner by the MOD overseas. And actually, I think the MOD find those cases as objectionable as those brought by, as Aileen put it, Johnny Foreigner. They find it difficult to be questioned about the treatment of the troops. Those are the questions that they find more embarrassing, I think, than the embarrassment of being called up on cases like Balhamusa, which we have to agree existed and was abominable and probably a breach of not just our convention rights, convention obligations, but a whole raft of our obligations in the Law of War and the UN Human Rights Framework. But that's not the issue. If we've got problems with the jurisdiction point, talk to our partners in the House of Europe. Say, we want a clarification of Section 1, that jurisdiction does not mean anything more than territorial jurisdiction. That's an international law issue. But all it does is send not just those who have a problem with our troops, but our troops themselves, if they have an issue around their right being respected in theatre, not to domestic
great institution. This question is kind of slightly unrelated, but it'll help for my dissertation. So I'm going to ask you. One of the things that stops democracy from going too far in the war on terrorism is a Human Rights Act. And in Australia, they don't have one. There's like no codified one. Do any of you know why? I mean, because why do we have one? They don't. I know it's a bit irrelevant, but it's kind of interesting.
Well, the history behind it is, I mean, we obviously didn't have the Human Rights Act for a long time. And
Yeah.
actually there was political resistance to it for a very, very long time. And actually I think that political resistance has remained in Australia.
We had it because we signed up to the European Convention on Human Rights. Hasn't Australia signed up to
No,
the convention? They have.
There's an interesting dynamic in the Australian